Welcome everyone, this is Amer from U Council. Today we'll talk about rules of civil procedure in Ontario courts. And this lecture is really for the beginners who have no idea what these rules are, what is their purpose, where to find them, what to do with them. So we'll cover those basic topics in this lecture. Before we begin, just a disclaimer that this course is not legal advice, so if you have any specific questions, please contact your lawyer or paralegal. Procedural rules, that's what they are. So we'll talk about what is their purpose, how many categories of rules are out there, how do you find these rules, where they are, and then what is this beast called practice directions? Are they additional rules, and what do you do with them, where to find them? There is a basic purpose of the rules of civil procedure, and that is to ensure that the process of a court action is fair. And so what I mean by that is, when you begin your court action, a claim against somebody, or you're defending a claim that is issued by someone else against you, that matter at some point will eventually go to a trial. The matter will be heard before a judge, and the judge will decide which party is right and which party is wrong. And it is important to ensure that by the time the matter is before the judge at trial, all of the steps that have been taken by parties are leading to a fair process, so that no side is unduly advantaged by any technicality to get to that. Because if the process itself is unfair, then it will be hard for a party to get a fair trial. So this is all about process, and these are codified in rules. Let me give you an example of that. So let's say you commence a court action against a party. So the process is, you draft what's called a statement of claim. You go to the court office, you pay the fees, the court fees, and then the court staff or the registrar will stamp that claim and then assign a court file number and then issue it and sign it. So that's now a document in court records that indicates that there is a claim that has been issued by a party against certain parties or a party. Now, for a defendant who has to respond to that claim, he needs to have clear knowledge that a claim has been issued against him or her, right? And so how does the court ensures that that person is actually received the documents? There is a whole process. There are rules that dictate how you can serve that claim. So for instance, if you put that claim in the mail, at the last known address of that person, the address, you put it in the mail and you send it out, and that person does not receive it, and you go to the judge and say, I have served the claim, I sent it by mail. If the person is not defending, I want you to grant me the judgment because that defendant is not here, right? And so that may not be a fair process because there's no way to confirm or verify that the person actually received that particular claim. So to ensure that the rules provide specific ways of how that claim can be served. So that's sort of an example of the claim, which ensures that that person has actually received it, and if at that point that person decides not to defend it, then the court can proceed with awarding a judgment against that person. So those kind of processes, and there are a large number of those processes relating to claims and defense and how you serve them, how many days do you have to respond to it, and how do you do the examinations for discovery, how do you set matters down for trial. So I'll kind of review that briefly so that I show you what kinds of rules are out there in the rules of civil procedure. But this is the basic purpose of these rules, to ensure that there is fairness in the process. Now, there are different categories of rules, and so it's not like you pick up one book and it says rules of the court and that's all you have to abide by or you have to understand. Unfortunately not. So just to give you an example, rules of civil procedure in Ontario, which is what we're going to talk about today briefly, that's sort of one category of rules. Federal court has its own set of rules, and so which may be different, which actually are different than rules of civil procedure. Then criminal courts have their own rules. Small claims court has its own rules, and they're called rules of small claims court. Human Rights Tribunal has its own rules. So depending upon which body, which court, which judicial body you are attending before, they may have their separate rules. And so you need to make sure, A, you find what those rules are, and then you understand them, you read them, and you comply with them. So all these categories are there, and then each province has its own rules. So we're talking about Ontario today, and then Alberta would have its own rules of civil procedure, and British Columbia would have its own rules of civil procedure. So you need to understand those rules. Okay, so focusing on Ontario rules of civil procedure, we're going to talk about where to find them, what is this thing called Courts of Justice Act, and what are the regulations, and we'll just sort of briefly overview the rules. So let's go to Google, and you type in, so you're at Google and you have no idea where to find these rules, so you type in rules of civil procedure. It's already here. CanLII is this website that provides free statutes of entire Canada, so you can find all the statutes and regulations in there. So let's click OK. You go to CanLII website, and then it will take you there. So rules of civil procedure, RRO 1990, regulation 194. I'll come back to it, to what that means. But these are the rules, and you see there's a table of content. The important point that I want to make, not really important for the purposes of you knowing these rules, but these rules of civil procedure are essentially a regulation under a statute called Courts of Justice Act. And I'll show you in a minute what Courts of Justice Act is. But these are regulations made under this specific statute. For your purposes, for practical purposes, whether it's Courts of Justice or whether it's regulation, they're all rules. So they all are equally applicable, and so you just need to understand that. Let's look at table of contents. And I was talking to you about what kinds of things that the rules deal with. So the general matters, parties and joinders. So what are different kinds of parties in a court proceeding? It talks about that in these rules. Commencement of a proceeding. A proceeding is a court action or an application that you commence in court, and that's called a proceeding. So how do you commence that proceeding? Here I'm talking about service. So service has three rules. How do you serve something? What are the time frames and whatnot? It's defined in these rules. If there's no trial, how do you end a matter disposition without trial? Pleadings are the core documents like claim and defense and reply and whatnot. So it defines what pleadings are. Then discovery, examinations, how these examinations are conducted out of court. All of these rules are there. They're fairly comprehensive. They pretty much cover every single thing that you may have to deal with in a civil court, and there is some rule regarding that, so you can find that out. Let's look into service of documents. I was talking to you about the service of statement of claim. I was giving you an example. So here's 16.0171, an originating process. Originating process is like a claim or a notice of application. It's defined in the rules. You can find that. But an originating process shall be served personally as provided in Rule 16.02 or by an alternative to personal services as provided in Rule 16.03. So the rule is specifically saying that when you have a statement of claim, you have to serve it personally. And then what does that personally means? That's defined in Rule 16.02, or it could be served by alternative to personal service as in Rule 16.03, right? So you go down to 16.02, and it says personal service, and then it goes on to define what a personal service is. So this is sort of a flavor of what these rules are, and we will in further lectures we'll sort of pick on each rule and we'll talk about it briefly so you get an understanding of what these rules are. I talked about Courts of Justice Act, so let's quickly look at Courts of Justice Act. So you go back to Google and you type in Courts of Justice Act. Again, if you want to go on CanLII, there are different sources where you can find these rules, but CanLII is sort of what I try to use most, primarily because I like the table of contents. Some of the websites don't have table of contents, and it makes it easier for you to review these websites and through table of contents. So Courts of Justice Act is sort of a larger act that deals with the administration of justice in Ontario. And it talks about what kinds of courts are in Ontario, what is the Court of Appeal, administration of the courts, how they are administered, appointment of judges and officers, court proceedings. So all of these things are in the statute. And if you notice this, Part 4 talks about rules of court, and this is where the rules of civil procedure come in. There are specific sections in the statute that allows for the creation of rules of civil procedure. Just quickly look at courts of Ontario. So you will see how many kinds of courts are there. Courts, Superior Court of Justice, Divisional Court, Family Court, Small Claims Court, Ontario Courts of Justice, and so there are all these kind of courts, and then Court of Appeal Ontario. So all these kind of courts have specific purposes, and you need to know which court your matter belongs to. You have to go to that court, to that province, to that territory, to that municipality, to that region, and then commence your court action in that regard. So that's where that's the process of finding them, and I gave you an overview of these rules, but by all means explore these rules, look at them, and find more about that. So what on earth is practice direction? What are these? What is their purpose, and where to find them? So just so you know, if it was not enough that the rules are so complicated, they are for different provinces, and then for different courts there are different rules. To make matters a bit more complicated, we have something called practice directions. So what is a practice direction? Practice directions are issued by, at least in Ontario, by a different regional court. So there's a region of Toronto, there's a region of Peel, and each region administers its courts differently. And so what happens? Why do we need practice directions? Because sometimes the regional courts require certain tailoring of the larger rules of civil procedure based upon, you know, how busy the courts are, based upon their system and whatnot. So they may have slightly different system. So based upon which region your case belongs to, you will have to look at the practice directions of that particular coast, which are, in other words, additional rules that the courts have provided, and you have to follow them. So you want to make sure that you understand the rules of civil procedure, and then you understand the relevant practice directions, because those are really the one that may modify certain rules or explain certain rules or put additional rules, and you need to follow those rules. So that's the purpose of practice directions. And where to find them? We go back to our friend Google, and let's say you type in practice directions. You see here practice directions, directions Ontario, and there are other practice directions. See Brampton, Court of Appeals, Newmarket. You already see those options there. So let's look at practice directions Ontario, and you find this link, ontariocourts.ca. This I believe is a government website for the courts, slash Superior Court of Justice /practice directions. So you click on that link, and then it has multiple things: practice directions, notices, and guides. And you review those. So let's say you want to go to a practice direction. You've brought a civil action or an application or a motion. You want to make sure that you click on it, and then you read all these rules, and they'll talk about different matters, rules applicable to all motions and application. If you are bringing a motion, you must read practice direction and understand what the rules are saying. So this is what they are, and you need to, now you know where to find them. You must read these rules and understand them. So you need to know, if you have a civil matter in Ontario, then you need to sort of read the rules of civil procedure, Ontario, and then read up on practice directions. So in summary, read the rules, understand them, and follow these rules, because they are essential. If you don't comply with these rules, there will be consequences, and a lot of times could be negative consequences, serious consequences, so you need to understand that. Regarding the last point, follow the rules, I just want to tell you sort of something from my own experience. When I became a lawyer many years ago, and we were getting this lecture from a senior litigator, he was talking about rules of civil procedure, and he, posed us this question: what are these rules? And some smart-ass lawyer said, oh, these are the Ontario rules, and these are for the fairness of process. And he like, okay, so what do you do with these rules? And he replied that you must understand these rules and follow these rules so that the process is fair. And that's where that senior lawyer interjected and said, wrong answer. He said, you want to understand these rules fairly well, but when you realize that these rules are not favorable to your client, you need to learn how to go around them. And that was an interesting comment. So it's not that you break the rules, it's not that you don't follow them, but if a specific rule is not in favor of your client, then you figure out how do you go around that rule to further your client's interest. So that's, fortunately, unfortunately, depending upon how you view the purpose of legal profession, But if you believe that the lawyer's fundamental role is to advance his or her client's interest, then that's sort of where you get these kind of interpretations of rules, which may be twisted, bent in different ways, and whatnot. So something to keep in mind, because whether you may follow the rules appropriately, the other side may try to bend them, and you need to be alert to these things. Hopefully this was helpful in terms of understanding some basic concepts about rules of civil procedure. What we'll try to do in the ensuing lectures is that we'll try to pick up on some of the important rules. We'll talk about it. What do they say? How do you understand it? Because these are sort of fairly complex rules, unfortunately not easily, not designed for everyday people in mind. And so we'll talk about this in more detail and basically make it sort of a fair game, make it simpler for you to understand these rules. So any comments, please write us, send us an email, post your comments, like us on YouTube, and we look forward to seeing you in the next lecture. Thank you for watching.